The Supreme Court chamber fell silent as Justice Amy Coney Barrett struck her gavel against the bench. Her voice sliced through the tension with precision. "Miss Leavitt," she began, "this court finds your repeated comments about our recent ruling deeply troubling. You're treading dangerously close to contempt." White House Press Secretary Karoline Leavitt stood still at the podium, facing the 9 justices who would determine her fate. At just 28 years old, Leavitt had become the youngest individual ever to face potential contempt charges from the nation's highest court. Barrett continued, her tone calm but stern. "You have 7 days to retract your statements and issue a formal apology. If not, this court will have no option but to refer the matter for criminal prosecution." The gallery gasped. Porters typed furiously into their phones, but Leavitt didn't flinch. Instead, she calmly opened a leather portfolio. "Justice Barrett," she responded with steady composure, "I've prepared a 15-page legal analysis, explaining why my remarks are not only constitutionally protected, but also legally sound. What followed would shock the court, the press, and the entire nation. Before we explore this unprecedented legal showdown, don't forget to subscribe to our channel and share your thoughts in the comments. Where do you believe the line lies between free speech and respect for the judiciary? Justice Amy Coney Barrett, appointed to the Supreme Court in 2020, had built a reputation as a formidable force on the bench. Known for her meticulous legal reasoning and composed demeanor, she commanded the respect of both supporters and critics. At 52, Barrett had become a leading figure on the court's conservative wing. Her academic background as a constitutional scholar and former Notre Dame law professor made her particularly sensitive to public statements she viewed as misinformed or deceptive. Karoline Leavitt, on the other hand, represented a younger political generation, appointed White House press secretary just 6 months earlier. She had quickly earned a reputation for her straightforward style and strong defense of the administration's policies. Few were aware that before her White House role, Leavitt graduated with honors from St. Anselm College, double majoring in politics and communications. She had also quietly completed legal studies while serving in prior government positions. The dispute began 3 weeks earlier, after the Supreme Court issued a contentious 5-4 decision in Fairfield v. Department of Education, limiting federal oversight of state education systems. During a White House press briefing following the decision, Leavitt remarked, "This ruling reflects a serious misinterpretation of precedent and legislative intent. The majority opinion disregards 70 years of settled jurisprudence in favor of judicial preference over constitutional principle." Her comments, sharper than typical White House responses, sparked swift backlash. Legal commentators debated whether her words crossed from legitimate critique into contempt. Conservative media outlets demanded repercussions, while progressive voices defended her right to speak out against judicial rulings. The consequences were substantial. If held in contempt, Leavitt could face jail time and the derailment of a promising political career. For the court, and particularly for Barrett, the episode became a pivotal test of judicial authority in a time when public institutions face mounting skepticism. The rare decision to summon Leavitt before the full court created a nationwide stir. Constitutional scholars struggled to find historical comparisons. The New York Times called it a constitutional crisis without modern precedent, while the Wall Street Journal described it as a direct clash between judicial power and the executive branch's communication rights. She stood in the chamber that morning, the gravity of the moment unmistakable. Her legal advisors had strongly urged her to apologize and withdraw her statements immediately. The White House counsel had even drafted a formal apology for her to read. The president had also recommended a more conciliatory tone, but Leavitt had spent 3 sleepless nights poring over Supreme Court rulings on contempt, free speech limits, and the complex history between government branches, which she found led her to choose a different course, one that could either validate her position or bring her career to an abrupt and dramatic end. Now, as Justice Barrett issued the 7-day ultimatum, the standoff had reached a decisive point. In the next few moments, Leavitt would either step back and apologize, as most expected, or directly challenge a Supreme Court justice's interpretation of the law. a move widely seen as professional suicide. Justice Barrett's face showed a flicker of surprise as Leavitt opened her portfolio. Rather than delivering the anticipated apology, she began to speak. Several justices exchanged glances. Chief Justice Roberts leaned in, clearly intrigued. "Ms. Leavitt," Barrett said, her tone edged with caution, "this is not a forum for debate. The court has made its stance on your comments very clear." Leavitt nodded respectfully. "I understand, Justice Barrett. However, before the court proceeds with any action, I believe I have a duty to outline the legal grounds concerning any potential contempt finding." Barrett's eyes narrowed slightly. "Proceed, but be aware that your response may influence the court's final decision." The warning was unmistakable, but Leavitt remained calm as she referred to her notes. "Thank you, Your Honor. I'd like to begin by referencing the legal standard for contempt, as established in Bridges v. California. Mention of the 1941 case drew visible interest from Justice Sotomayor." Leavitt continued in Bridges. "This court ruled that even sharp criticism of judicial decisions is protected by the First Amendment, lest it poses a clear and present danger to the administration of justice. My statements, while direct, did not meet that threshold." Justice Alito interjected. "Ms. Leavitt, you said this court ignored 70 years of precedent. That's more than criticism, it questions the court's integrity." Leavitt turned to face him. Justice Alito in New York Times v. Sullivan.
The court held that public debate should be uninhibited, robust, and wide open, even if
it includes harsh and sometimes offensive attacks on public officials. The ruling explicitly included judges in that protection. The chamber remained silent as Leavitt steadily addressed each possible contempt concern. In Craig v. Harney, she continued, the court emphasized that judges must be resilient, able to endure strong criticism. The ruling confirmed that courtroom events are public matters and open to scrutiny. Justice Barrett maintained a firm but focused expression. "Ms. Leavitt," she said, "those rulings primarily apply to private citizens and the press. You spoke as a government official. That may be a critical difference." Leavitt had been waiting for this moment. She turned to page 8 of her analysis. "Justice Barrett, I would respectfully point the court to Garrison v. Louisiana, where the issue involves statements by a government official. In that case, the court ruled that even critical remarks made by a district attorney about judges were protected. It emphasized that speech on public issues isn't just self-expression, it's fundamental to democracy." The tension in the room rose. It was clear now that Leavitt wasn't simply making a rebellious stand, she was building a carefully grounded legal argument. Reporters had stopped typing, caught off guard by the unexpected direction. Justice Kagan leaned toward her microphone. "Ms. Leavitt, your knowledge of precedent is commendable. But there's a line between criticizing a ruling and suggesting the court intentionally misinterpreted the law. The latter implies bad faith." Leavitt acknowledged the point. "Justice Kagan, I understand the nuance. However, in Wood v. Georgia, this court protected a sheriff's statements directly accusing judges of bias and political motives, remarks far more direct than mine. The ruling noted that because elected officials play a vital role in society, they must be allowed to speak freely on matters of public importance." Justice Barrett's expression had subtly changed, from stern disapproval to a more measured consideration of Leavitt's argument. "Ms. Leavitt," she said, "you've referenced several important cases, but none seem to directly apply to statements made by White House officials were questioned about recent Supreme Court rulings." Justice Barrett acknowledged the concerns, but Leavitt responded firmly. She argued that in the absence of a clear precedent limiting such speech, the law should lean toward protecting it. She cited Texas v. Johnson, where the court affirmed the nation's strong commitment to free and open debate on public matters. What started as a simple reprimand in the chamber quickly shifted into a deeper legal discussion. Leavitt referenced relevant cases with striking accuracy, applying them to her situation. Even Justice Thomas, who seldom spoke during hearings, decided to comment. "Ms. Leavitt, while your legal arguments are well articulated, we must still consider the need to respect institutions. Your remarks could weaken public trust in the judiciary." Facing him directly, Leavitt responded, "Justice Thomas, I appreciate your concern. But in Landmark Communications v. Virginia, the court ruled that harm to an official's reputation isn't a valid reason to restrict otherwise protected speech. The ruling also made it clear that a judge cannot use their position to shield themselves from public critique. The courtroom fell quiet as the weight of the quote settled. The tension had clearly risen. Instead of retreating, Leavitt had steered the proceeding into a high-level constitutional debate and showed no signs of relenting. Justice Barrett, while reconsidering her stance, leaned in. Ms. Leavitt, are you suggesting that there are no boundaries to how administration officials can describe court decisions? Not at all, Justice Barrett, Leavitt replied. There are limits. Direct calls to ignore court orders would clearly violate the line drawn in Bridges. But criticizing legal logic even strongly is still protected under the court's own decisions. As Leavitt continued her careful analysis, the mood in the chamber shifted again. What began as a disciplinary matter had evolved into an unexpected lesson in constitutional law. The youngest voice in the room had shown a mastery of precedent that surprised the justices. A deep stillness settled over the room as Leavitt turned a page in her notes. Her steady voice now sounded even more confident. If I may, she said, I'd like to discuss the historical background that supports the constitutional protections for my remarks. Justice Barrett, who had initially planned to give a straightforward warning, found herself silently signaling approval to continue. The shift was now unmistakable. Several justices were visibly more engaged. Throughout U.S. history, Leavitt went on, tensions between the executive branch and this court have produced far stronger criticisms than mine, none of which led to contempt charges. She offered examples. President Jefferson labeled Chief Justice Marshall's opinion in Marbury v. Madison as twistifications. President Jackson famously said, John Marshall has made his decision, now let him enforce it. President Lincoln publicly challenged Dred Scott v. Sanford in his first inaugural address. Leavitt paused, allowing those historical moments to sink in before citing more recent instances in 2010. President Obama criticized the Citizens United ruling during the State of the Union with 6 justices present. In 2017, President Trump referred to a judge who ruled against his administration as a so-called judge. Neither faced contempt. Justice Sotomayor interjected, those were presidential remarks. Your position is different. With respect. Justice Sotomayor, Leavitt replied without delay. The legal test for contempt doesn't distinguish between a president's speech and that of other executive officials. Press secretaries, too, have long critiqued court decisions on Ziegler under Nixon, James Brady under Reagan, D.D. Myers under Clinton, and Kayla McEnany under Trump, all made statements critical of Supreme Court rulings. Then came the turning point of her argument and examination of her own words against the legal standard for contempt. If I may direct the court to my exact phrasing, she said, handing over a transcript of her press briefing. I stated that the ruling reflects a fundamental misreading of precedent and legislative intent. This was a legal argument, not a personal attack. I stated that the majority opinion disregards 70 years of established legal precedent. That's a comment on legal methodology, not on the integrity of the justices. She looked directly at Justice Barrett. Under Bridges, contempt of court requires a clear and present threat to the functioning of justice. My remarks posed no such threat. They challenged the reasoning behind the decision, not the legitimacy of the court itself. Barrett, who had entered the room confident in her stance, now faced a situation she hadn't expected. The press secretary she had called in for a formal reprimand was now delivering a detailed constitutional argument, citing the court's own rulings. Ms. Leavitt, Barrett began, while your grasp of precedent is impressive, there is still the matter of your role as White House press secretary. Your statements carry the weight of the executive branch. It was the opportunity Leavitt had been waiting for. She moved to the final part of her argument. Justice Barrett, that's an important distinction I'd like to address. In Garcetti v. Ceballos, this court ruled that when public employees speak as part of their official responsibilities, their speech may receive limited First Amendment protection. However, the court made it clear that this applies to internal workplace speech, not public commentary on matters of public interest. Leavitt's command of the case law was extraordinary. She even cited specific pages and direct quotes from the rulings. Several clerks were seen hurriedly verifying her references only to confirm they were accurate. More importantly, she continued in Lane v. Franks. This court reaffirmed that public employees who speak on issues of public concern are entitled to strong First Amendment protection. A Supreme Court decision affecting national education policy is undoubtedly a matter of public concern. And as press secretary, my job is to publicly communicate the administration's views on such matters. The gallery was captivated as Leavitt carefully built her case. What began as an attempt to reprimand a junior official had turned into a lesson in constitutional law. Justice Barrett, aware of how the tone had shifted, tried to regain control. Ms. Leavitt, this court has the right to defend its institutional integrity. Your remarks, legal status aside, showed a lack of respect for the court. Leavitt nodded respectfully, then delivered her strongest point. Justice Barrett, I hold the deepest respect for this court as an institution. That's exactly why. I believe it's important to have serious, respectful debate about its decisions. She paused, then quoted from one of Barrett's own writings. As you wrote in your 2019 article in the Notre Dame Law Review, respectful disagreement is not disrespect. In fact, the ability to critique judicial reasoning is essential to a functioning constitutional democracy. The chamber fell silent. Barrett's own words, quoted precisely and in the right context, had effectively undermined the rationale for the contempt charge. Several justices looked toward Barrett, awaiting her response. After a long pause, she finally spoke. Ms. Leavitt, I appreciate the depth of your presentation. The court will consider the arguments you've made. She looked to Chief Justice Roberts, who gave a subtle nod before addressing Leavitt. This court will take your statements under advisement, Roberts said. A decision will be issued within 48 hours. This proceeding is adjourned. As the justices rose, the gallery buzzed with whispered discussions. Many had expected a straightforward disciplinary hearing. Instead, they had witnessed something entirely different. A young press secretary had given a compelling constitutional defense before the highest court in the country. Using its own rulings to support her right to speak out, her success wasn't measured by applause or celebration. It was clear in the way she had turned what should have been a reprimand into a serious legal debate. As she gathered her notes and prepared to face the crowd outside, both supporters and critics recognized the moment. A legal mind had just stood its ground before the Supreme Court. The instant Karoline Leavitt stepped outside the court building, she was surrounded by reporters. Cameras flashed and questions flew from all directions. But she didn't speak off the cuff. I've presented my case to the court, she said calmly. Out of respect for their decision-making process, I will wait to comment further until they announce their decision. This measured tone, so different from the media frenzy around her, only amplified the weight of what had just occurred. Within minutes, legal scholars across the country were analyzing the confrontation. At Georgetown Law Center, Professor Lawrence Tribe was speaking with a group of stunned students. What we saw today was unprecedented, he told them. A press secretary turned a contempt hearing into a First Amendment seminar, using the court's own rulings accurately and effectively. CNN's legal analyst Jeffrey Toobin, visibly energized on air, said, I've covered the Supreme Court for decades. I've never seen anything like it. Leavitt didn't just defend herself, she taught a constitutional law class. Guest lecture on First Amendment jurisprudence delivered directly to the justices themselves. Karoline Leavitt's performance impressed conservative legal circles, albeit with some restraint. Michael Leake commented, while I may not fully agree with Leavitt's framing of the court's ruling, her legal defense today was exceptionally well argued. She's brought forward serious constitutional concerns the court will need to evaluate with care. As legal analysis swept across cable news and social media platforms, a parallel narrative began to surface, one that the public had previously overlooked. Leavitt's background in law, completed quietly while serving in government, had never been spotlighted in her official White House biography or public appearances. Within hours, the Washington Post released a profile titled Behind the Press Secretary Podium, Karoline Leavitt's Hidden Legal Background. The article revealed she had earned her law degree through an evening program while working on Capitol Hill, achieving an impressive 3.9 GPA despite her demanding political responsibilities. A former professor, speaking on condition of anonymity, described her as one of the most talented constitutional law students I've ever taught, someone who could recall case law verbatim and apply it with rare insight. Inside the White House, the mood shifted from concern to cautious optimism. Advisors who had earlier urged Leavitt to issue a formal apology now gathered in the Chief of Staff's office, watching as legal commentators praised her across multiple networks. "She never told us she was going to do this," one senior advisor was overheard saying. "We had a written apology ready to go. Nobody expected her to spend the weekend building a constitutional argument." The president, initially worried about the political consequences of a potential contempt ruling, personally called Leavitt. According to sources familiar with the exchange, he told her, "You made history today. Whatever comes next, I'm proud to have you representing this administration." Meanwhile, in an extraordinary session inside the Supreme Court chambers, the 9 justices, who rarely hold emergency conferences, gathered to confront the unexpected constitutional challenge Leavitt had brought forward. Sources close to the court, later speaking to The New Yorker, reported that Justice Barrett began the meeting by noting the situation's complexity. "We summoned Ms. Leavitt, expecting a routine contempt hearing," she stated. "Instead, we received a well-developed First Amendment defense grounded in our own rulings. We must consider our response carefully." Multiple justices, regardless of their stance on Leavitt's original remarks, reportedly expressed respect for her legal skill. Justice Kagan was said to have remarked, "Whatever our decision, I believe we all now hold a deep respect for her constitutional command." As the court deliberated, law schools across the country rushed to adapt the hearing into their curricula. Harvard Law announced a dedicated symposium titled Executive Speech and Judicial Criticism: Constitutional Boundaries After Leavitt. Stanford Law scheduled a panel featuring former Supreme Court clerks to examine the constitutional issues raised. Emergency legal commentaries began appearing in online journals, with Yale Law Journal's Forum publishing a notable piece, Contempt, Power, and Criticism: The Court's Dilemma After Leavitt's Defense. The article detailed the difficult position the court now faced: either step back from its contempt threat and risk appearing to validate Leavitt's arguments, or move forward despite her strong First Amendment defense. Public reaction surged. On social media, hashtags like #LegalGenius and #SupremeShowdown trended nationally. Young women across political lines voiced admiration for Leavitt's composure under scrutiny. TikTok videos breaking down her delivery style garnered millions of views. Exactly 48 hours later, the Supreme Court delivered its decision. In a rare unanimous 9-0 ruling, the justices announced they would not proceed with contempt charges. The brief statement acknowledged the significant First Amendment issues raised and reaffirmed the constitutional right to engage in vigorous debate over judicial rulings. Justice Barrett issued a concurring opinion that legal scholars are expected to analyze for years. While this court retains the authority to safeguard the integrity of its proceedings, she wrote, "We must also honor the constitutional constraints on that." Authority's Leavitt's presentation reminded us that our precedents consistently uphold the right to critique judicial decisions even when that critique is sharp or uncomfortable. A democracy that cannot tolerate criticism of its courts is no democracy at all. This decision marked not just a legal turning point, a personal victory for Leavitt, but more importantly, a landmark constitutional affirmation of the right to critique judicial rulings. Legal historians would later recognize this as a pivotal moment in the evolving dynamics between the executive and judicial branches. At her first press briefing after the court's decision, Leavitt remained calm and composed. When asked about her widely praised legal defense, she replied modestly, "I have a deep respect for the First Amendment and for the Supreme Court as an institution. I'm thankful the justices approached the constitutional issues with such care. The case's impact extended well beyond the initial dispute. Law schools reported a noticeable rise in applications, especially from women and young professionals who were inspired by Leavitt's stance. Constitutional law professors also observed a growing interest among students in First Amendment rights and the separation of powers. Perhaps most notably, The dynamic between press secretaries and the judiciary began to shift. Future administrations adopted a more measured tone when discussing court decisions, concentrating on legal arguments rather than questioning the intentions of the justices. At the same time, the court showed increased restraint in its responses to executive critiques, acknowledging the constitutional boundaries that Leavitt had so clearly underscored. 6 months later, Justice Barrett invited Leavitt to speak at Notre Dame Law School on the topic of executive-judicial relations. The event, which sold out almost instantly, marked a significant shift from opposing sides in a contempt case to partners in constitutional discourse. In her introduction, Barrett acknowledged the unique context of their first major interaction. Ms. Leavitt reminded us that open, informed debate on judicial rulings strengthens, rather than undermines, our constitutional framework. Legal expertise surprised some, though it shouldn't have. In America, legal insight can come from unexpected sources, and constitutional wisdom isn't confined to judges or legal scholars. As Leavitt stepped up to the podium to enthusiastic applause, it was clear her transformation from a potential contempt defendant to a respected constitutional advocate was complete. What began as an effort to stifle dissent ended up amplifying. Atan set a new benchmark for safeguarding political speech. Leavitt proved herself a formidable legal mind, not through academic titles or a seat on the bench, but by skillfully applying constitutional principles when it truly mattered. If you found this breakdown of a historic constitutional debate insightful, please like and subscribe to our channel for more thoughtful legal and political commentary. Share your views in the comments. How do you think we should balance judicial authority with freedom of expression? And don't forget to hit the notification bell so you never miss our latest updates.